Hello and welcome to Analysis. The government's terrorist prevention and investigation measures are about to expire. They were brought in 2 years ago to replace the previous Labour government's control orders. Now the so-called TPIMs measures are said to be withering on the vine. In a report published last Friday, the Joint Committee on Human Rights stated that TPIMs were not effective as investigation measures and given the subject's awareness that they were under scrutiny. In the light of this report and mounting criticism of their utility, will the renewal of these orders seem less attractive option at Westminster? How effective have the measures been anyway? And has the TPIM regime failed in its own terms? Joining me in the studio are Alex Stevenson, parliamentary editor of politics.co.uk website, human rights lawyer Sagir Hussain. On Skype, we have Kerry Kalim Boulevant, TPM project coordinator at Caged Prisoners, and on the phone, Dr. Julian Richards, co-director of the Centre for Intelligence and Security Studies at the University of Buckingham, and Margaret Gilmore, senior associate fellow at the Royal United Services Institute. So, what exactly does having a TPIMs mean? Some of the restrictions that you may have placed upon you include these: not being able to leave your house overnight, not being able to go beyond the geographical boundaries decided by the Home Office, being permanently required to wear a monitoring tag, being prevented from talking to or meeting with whoever you want, not being able to stop the police or staff of a monitoring company entering and searching your home without a warrant, not being able to have friends or family to your home unless approved by the Home Office, approval which can be removed at any time, not being able to travel overseas, and if you breach a TPIMS notice, you could be put in jail for up to 5 years. So what exactly does having a TPIMS order placed on you do to you? What are the meaning?
It's like having bail conditions. When somebody is facing criminal proceedings, you are given conditions of bail that you're not in custody in a remand in a prison, but you can live at home, but you have certain conditions you have to comply with. Now, the difference between bail conditions and the TPIMs is that bail conditions apply in a criminal proceedings case, which is quite fundamental to the whole principle. And this is why all Home Secretaries have actually found it very difficult to get other people, intelligent, informed people, to actually agree with the principle is that you're taking away somebody's liberty, imposing restrictions on somebody's liberty without them having to go to criminal proceedings. And that's why I think TPIMs are so unpopular.
So let me see if I've got this right. So you're not able to leave your house overnight, you're not able to go beyond certain geographical boundaries, you're being permanently required to wear a monitoring tag, and these are all things that are imposed on somebody who hasn't actually been found guilty of anything.
Well, precisely. Those are the kind of conditions, restrictions, as I said, on people's liberty that just been imposed at the whim of the executive, normally the Home Secretary, based very often on secret evidence and not being tested in a court of law, like the normal principles that apply in English law.
Alex, how on earth have these got onto the statute book? Because it does seem to be a breach of all sort of natural justice.
Well, the new Labour government, which was responsible for TPIM's predecessor, control orders, had a pretty bad track record when it came to striking the right balance between civil liberties and protecting the public from terrorism threats. And when the coalition government was formed, it was clear that the Conservatives and Liberal Democrats were going to do something to try and address control orders. The hope then was that they would get rid of them altogether. But instead, what we had was about a year of negotiations in which the Liberal Democrats, who had championed civil liberties while in opposition, found they were unable to convince Conservative ministers in government to really water these down significantly. So TPIMs was the result. Yes, they're not as bad as control orders, which New Labour have put in place, but they remain a fundamental removal of freedom of liberty from people who haven't been convicted of any criminal offence. The basic problem with them remained.
Dr. Julian Richards, let me bring you in on this. I mean, it seems pretty hard to justify this on when you've got the state essentially taking powers to itself over individual citizens with no due process.
Yeah, and there's no doubt these are very extraordinary measures, but they're measures for extraordinary times and an extraordinary level of threat. And everyone involved in the process agrees that they're not great and they're not what we would ideally want, but they're the best that we can do in this particular situation at the moment.
Margaret Gilmore, aren't they failing in their own terms? Isn't this the gist of the report that we saw last week?
I think they are. I think the numbers of people on them are so tiny, all but possibly one, and they're all so secretive, we don't quite know how many, but possibly one person may still be on one by the end of this month. But really, the numbers are so tiny. The fact that they are outside our criminal justice system is not a good thing. I think almost everyone's in agreement on that. And the numbers, less than 10 involved, I think they are looking much more actively for other ways of dealing with suspects, and that has to be the way forward.
Okay, and Kerry, just let me bring you in as our last guest in this session. Is there any proof that people who've been placed under these measures, that the investigation, that's what they're called, there has been an investigation, and this has ended up in them going through the courts?
Well, no one who's ever been put on a control
Kerry,
order
can you hear me?
Hello? Can you hear me? Hello?
Yeah,
Hello?
go ahead. Go.
Okay. Nobody who's ever been put on a control order or a TPIM has ever then faced a criminal charge for any terrorism-related offence. David Anderson, in his most recent report on TPIMs, actually said that the name is contradictory. You can't prevent something and investigate it at the same time. You're doing one or the other. You're either preventing something from happening or you're investigating it. So these measures are fundamentally contradictory to their very aim. I'd also disagree with Alex a little bit in how much they were watered down. The changes were very, very minor, and especially in terms of the way you live your life when you're under an order, it hasn't changed at all. The whole issue of moving over to TPIMs is largely a rebranding exercise and a bit of a false dawn.
Okay, Dr. Richards, just let me put that point to you. Do you think that's true, that you can't have something which is supposed to be preventing somebody from doing something at the same time investigating them? I mean, that's a fair point, isn't it?
Well, in lots of ways, yes, it is a fair point, and to a certain extent, it's a question of what we actually call these things. And you know, control orders was for all their problems, and they definitely did have lots of problems. It was fairly clear what they meant. So the TPIM is a rather sort of clumsy way of trying to make it sound like something different, and probably isn't quite the right word. I noticed that they've been talking about terrorism prevention orders, TPOs, as a possible better expression for this. But I actually agree with your last speaker that they're not actually greatly different from what control orders did previously.
I mean, so yeah, this is part of a wider pattern between the last two governments, isn't it? I mean, the prevent scheme, kind of hit the buffers at the end of the last Labour government, but we've got a kind of son of prevent going on under the current Tory administration. And do you agree that this is, a rebranding, but not is a distinction without a difference here between these two?
There were some subtle differences, but on the whole, as both people said, Kaleem and Mr. Richards said, there isn't much difference between the two schemes. But I think what we need to add here is that whether it's Labour or whether it's the Conservatives, when you have somebody from the security services coming over and putting pressure on the politicians that we are telling you this, and we live in such a risk-averse culture at the moment where no politician wants to take the risk. The reality is we need to put those security services personnel under much more scrutiny and say, why is it that over the last 10, 15 years, suddenly what they say can override what the politicians want? And those are the fundamental values, shift in values that we've seen through the last 10, 15 years. And I think we need to address that rather than look at the symptoms like TPIMs and control orders and say, well, how can we tamper with that? The real issue is, when did Parliament, a country like Britain, which has 1,000 years tradition of free Parliament, free democracy, suddenly says, well, it doesn't matter what Parliament want. If the Security Services says we want a snooping charter, even if Parliament doesn't want it, we'll let them. If Security Services says, look, we want to put these people, restrict their liberty, even the Parliament and most sort of informed opinions say, well, that's not really British values. Why is it that we allow them to continue with that? I think that's the debate that should be having now.
Alex, do you think that that this transition you were suggesting perhaps there have been some differences. Do you think they're mainly cosmetic, or is there any? Would you defend the idea that there has been some real differences?
Well, no. Ultimately, the principle here stays the same, which is that you have people who there's no evidence against them that will stand up in a court of law that will get them convicted, that are having their liberty fundamentally deprived. So no, I accept the point that they're broadly cosmetic. I think the Liberal Democrats, when they were going through this negotiating process with the Conservatives, were trying hard to play them up and make a big deal of them. But no, sure, absolutely, they're basically the same.
Okay, so we've heard now. Okay, there's a series of fairly draconian restrictions on the liberties of people who have never been convicted of anything. We've also heard that nobody has been convicted at the other end of this process. Is there any appeal? If it happens to you, have you got any recourse saying, look, guys, this is done just, lift this from me?
Well, there's huge question marks over the ways in which this operates, and it's not clear from what we've seen, the experiences of those who have gone through this, that anything, they might have an appeal opportunity here or there, but really it doesn't seem to be making much difference when it actually comes to the cases on the ground. And what is really striking is that we're talking about this now because the 2-year period has expired, but Home Office source I was speaking to earlier today told me that it's very simple. The Home Secretary simply has to reapply, and then we get another 2 years. So, and actually, this was one of the concessions. The big victory for the Lib Dems was that TPIMs, unlike control orders, would be time limited to 2 years. But ultimately, Home Office is saying that it's back to square one in the sense that you've got to go to the Home Secretary's got to make the application to a judge to get them again. But ultimately, what difference does that make?
So do you think that's going to happen? Because we've had this with other. The Prevention of Terrorism Act was supposed to be time limited. It's been with us, for a couple of decades, more than
we started in the mid-70s, didn't it? The emergency terrorism provisions where every year they were supposed to be renewed. And that's the problem with when you give powers to the state. And unless we have people watching over them very carefully, the judiciary and the politicians and the chattering classes really watching it carefully and not fall for the hype and the fear, the climate that's created, you're going to have these issues become permanently embedded into the British legal system. And unfortunately, we've seen with the Terrorism Act 2000, it has become permanently embedded when even at the height of the IRAs, there are bombings, where people still felt that they were so severe that they had to be renewed every year. And that's what worries me, is the fact that normalization of this debate where, we need something. We need something. Do we really need something? Let's have a look at what does it prevent. Let's have a look at does it really make us safer, or is it just basically allowing a very authoritarian Home Secretaries or governments to say, well, let's pick on this individuals. They're unpopular, and most of the people will fall in line with it, and the state will end up with more powers. The problem with that, as we've seen with GCHQ and NSA, so scandals, is that gradually the state will want to have more and more people under its watch. And that's why I think people are now certainly waking up and thinking, and I think some sort of fight is going on at the moment.
So thanks very much for being with us for this part of the programme. Dr. Richards, is that a legitimate concern that I guess if I was to rephrase it, what Sagir is saying is that the state is hopscotching from one set of suspect communities, if you like, to another, and sustaining what are introduced as temporary laws into a permanent state of surveillance?
No, I wouldn't actually agree with that, and I think that that's not a fair characterisation of the process, actually. I mean, one of the points about TPIMs over and above control orders was that they had this 2-year limit for a start, that the Home Secretary has to be convinced that they're necessary. The High Court has a role in this, not only in the initial granting of a TPIM, but in continual review. You can go to the High Court if you think you've got a case, and you can have one quashed or revoked. And at the end of the 2 years, they can only reimpose it on the basis of new evidence. Now, I take the point that the evidence in this context isn't quite the same as it would be in a court of law. It's secret evidence, but it still has to go through that same process. And it's worth saying that there's a lot of political pressure on this. We mentioned the Liberal Democrats earlier. I mean, they're really not keen on these sorts of procedures. So there's lots of political pressure inside the coalition. There's also an independent reviewer of counter-terrorism legislation who is supposed to be independent, and if he didn't like these things, he would say so very robustly.
So what's your guess then? Do you think that they won't apply to have these renewed, or do you think they will apply and they won't be granted, or do you think they will apply and they will be granted?
I think they'll make a lot of it is to do with politics, basically, and we've seen that there's for the government, some very unfortunate politics around this recently, not least the two characters absconding so easily who had TPIMs placed against them. I suspect that a number of them will be reimposed, but I don't think all of them will be by any means.
Okay. Margaret Gilmore, what do you think about this, the question that supposedly temporary measures are kind of shunted on from one terrorist crisis to the next and therefore become part of the permanent legal structure?
Well, the truth is that they started out as completely draconian. People were put into Belmarsh jail. First of all, foreign suspects who they couldn't lock away, and then British suspects. And time after time after time, in the last 8 or 10 years, the courts have challenged the politicians and said this is not legal and you can't do it. This is badly written legislation or it's against different laws. And now we've got to the state where the politicians are holding on to very watered down powers compared to what was there in the first place. Because they want to keep that power, because they don't like it when the courts say, actually, you may suspect them of something, but in a democratic society, the law of the land says this. My personal view, they're more trouble than they're worth at the moment, that we're talking about a very small number of people. TPIMs are slightly, in my view, less strong than the control orders. In most cases, it is easier to use the internet, for example, but they haven't worked. They haven't led to any real convictions. And as I say, I think more trouble than they're worth. And there are big issues over any appeal process because these appeals are heard in secret, so we don't know how strong or weak the appeal process is.
Okay. Kerry, do you take that view? Do you think that the courts have, I think what Margaret's suggesting really is that the courts have managed to push the politicians back and that they haven't been able to sustain the kind of level of surveillance and repression that the original means included?
Well, she's exactly right. I mean, you've got to take these things in the context of the fact that it started off with indefinite detention in Belmarsh. It was then moved on to control orders and then watered down again to TPIMs because so many of the fundamental aspects of control orders were getting struck down by the courts. The problem is that these processes take a very long time. Each sort of segment has taken 5 years or so to end. So you had roughly 5 years or 4 years of indefinite detention, and you had around 5 years of control orders. TPIMs, because they're so useless and ineffective, have only lasted 2 years, but that's not because they've been struck down by the courts. That's because they're actually serving no purpose. And during this time, how many lives have we ruined? I myself was on a control order for 2 years until a judge struck it down as there was no basis and no evidence. And all this talk of like the High Court overlooking it and checking these things, it took 2 years for me to get before a judge who, when he saw it, said he would have quashed it after a day.
And what was the reason given to you when? And how did it happen? Did the police just arrive at your door and say, "Okay, mate, you're under a control order"?
Well, pretty much. I was in the street helping a friend make up some concrete to do some patioing in his back garden. The police came up to me like a scene from a movie and said, "Are you Mr. Bullivant?" "Yes, we're serving you with a control order." They handed me a brown envelope and that was it. My liberties were gone. And that was the full extent of my due process for pretty much 2 years. Even to this day, another 6 years on, I still don't know what the full evidence against me was. The evidence that I've been given or that I found out on my own was very limited. And it's worth remembering here that we're destroying the basis of British justice, which is an adversarial court system with a jury of your peers. In my case, we found out some of the secret evidence. One of the pieces of secret evidence, so I won't go on too long, was a phone call made by a friend of my mother who'd got drunk to the anti-terror hotline saying, "Look, this he's young, he's 21, why would he become Muslim? Why would he want to go travelling? He must have been brainwashed." And so in a drunken state, she made that phone call. It was only when my case appeared on the news that she told my mother about that. we found out about this anonymous phone call and we checked it out with them in the court. We said, look, to the police officer and to the MI5 officer, was the person spoken to? Did you check it up? Did you do due diligence to find out why they were making these accusations? And the answer again and again from both sides was no, no, no. And why should they? They have no reason to put due diligence into their research, into their investigations, because they know the evidence won't be tested.
Okay, well, I think that's going to bring us to the conclusion of this part of the discussion, but do rejoin us after the break, because we'll be looking at further implications of what the committee that reported last week said about TPIMs and whether or not they can actually be sustained or actually useful in their own right. That's after the break. Do rejoin us for the second part of analysis.